Let's talk about Supreme Court. Before you get all emotional about how we should go about a Supreme Court, let us look at some of the facts, some historical facts, what has been done before, and what can and should be possibly done now. Well, let's look at the facts. If you like this video, I ask you to subscribe and check out some of my other videos. Or even if you don't like this video, you can still subscribe and watch other videos. Sometimes its second opinion is good as well. So, Supreme Court was established by a constitution. It's one of those third legs of our government, judiciary. For over 140 years, about 145 years actually, Supreme Court didn't even have its own building. It started meeting in New York, then it moved to Philadelphia, met in different buildings. At times, justices were even meeting at the private homes. Until about 1801, that court moved to Washington, D.C., and it started meeting. Supreme Court building, as we know it today, that granite big building on top of the hill, their Capitol, was actually built for in 1935 with less than $10 million. Back in the day, you could buy a lunch with $1 million, I guess, or a little more than that. So, so what are some of the historical facts about the Supreme Court? Has there always been 9 justices? No, that's not the case. Originally, actually, there were only 6, and throughout the history, there were as many as 10. Since about 1837, the number was bumped to 9, and we have more or less had 9 ever since that time. So the number is not fixed. The Congress can change the number of it, but number 9 was kind of like a good. You can vote 5-4, 6-3 type of thing. So to prevent court being locked 4-4 or 3-3 originally, so that was not considered our best of idea. The youngest member of a Supreme Court was only 32 years old. And of course the oldest ones are up to 90 or because it is a lifetime position. So most of justices do not last a lifetime. About 50% of the time they either resign or retire or whatnot. They chose not to drag it on till the last day. But it is a lifetime appointment. So it's one of those guaranteed jobs, I guess. Once you are in, you're in. Being appointed, the only way to remove is to impeach the justice, and that is one option that the Congress has if there is some great violation of the law or treason or whatever. The Congress has the power to impeach the justice, just as they have a power to impeach the president. A couple other interesting things about Supreme Court. 5 justices were never married. 2 actually appeared on a dollar, on the currency. One was John Marshall, was on a $500 bill, and Salmon Chase was on $10,000 bill. Well, we don't have. Does Supreme Court justice have to be a lawyer? No, they don't. President can appoint or recommend Joe the Plumber. And Joe the Plumber, with no legal background, becomes the justice of the Supreme Court. Does every president gets to appoint justice? Well, that depends. If during their term there's an opening, they get to appoint one. About 4 presidents, I believe, never got a chance to appoint, of which one was Jimmy Carter. During his 4 years, the opening just wasn't there, and he didn't appoint anybody. Some of the justices were actually never been judges before. One in case is Kagan, one of the latest appointees by Obama. She was never judged before. I think she was a professor at the law school. The basic rules are: the president appoints, recommends, and Senate votes on it and approves. The rules of the Senate dictate how this is done. In the past, Senate had the rules where they had to have a 60 votes majority out of 100, and I believe it was a Harry Reid back in early 2000s that changed the rules because it suited the Democratic Party at the time to roll that back to 50, just plain majority. Well, here we are today, where there's a debate: should president appoint a justice during the election cycle or not? Let's look at some facts. In history of our country, it happened 29 times that a vacancy became available, or open vacancy seat, in a presidential election year. 29 times. 19 times was president and the Senate were of the same party. 19, 17 of those were justices were confirmed. On the instance where parties were of different flavor, president and the Senate being of different party, out of 10 times, only twice did the Senate confirm. So you see why politically what it's done. You want to have a party and the president, the Senate and the president, to be of the same party, because politically it makes a lot more sense, because that nominee in all likelihood is going to go through. Everybody does it. Republicans do it. Democrats do it. So, should the president nominate a justice during this election cycle? Yes. Why? Well, because it's constitutional duty. His constitutional duty to nominate the justice. And the Senate has a constitutional duty to vote on it, yes or no. Historically, these votes were pretty simple. The parties would kind of vote, once the president is elected, he nominates someone, well, figure out, as Obama told us during his election, quote, elections have a consequences. Meaning, the other party wins, you don't like it, well, they get to nominate who they want. So, historically, back in the 90s and early 2000s, a lot of nominees were basically sliding through the process, and it was nothing as painful as it is today. For example, Ginsburg herself was nominated 96-3. Souter got 90 votes. Stephen Breyer got 87. Lately, things kind of start slowing down. Sotomayor was voted in 68-31, and Kagan got in at 63-37. Still, a lot of people crossed the party lines and voted, yeah, okay, I guess it's his nomination, and he won the presidency, so therefore he gets to pick the Supreme Court justice. What about Justice Ginsburg's last death wish that nominee should be held till after the election? How meaningful is that, if at all? It's actually meaningless. Why? Because the Supreme Court justice is an appointment. It's not your seat to keep or give away. Imagine if Scalia, when he was down on his deathbed, says that my death wish is that Supreme Court abolish abortion, and abortion becomes criminal act. Would Chuck Schumer give it a thought or spend a time on it, demanding that justices' last wish be honored? Of course not. Because everybody does. It's meaningless. It's not their position to give. Just like if Trump tomorrow, proclaims that, well, I think my next president, my last wish is for Rush Limbaugh. Or, I don't know, pick anybody. Ted Cruz is a new president. It's meaningless. We vote on that. It's not his to give. So the position of a Supreme Court justice, it's not their position to give. So her last wish it means nothing. It should mean nothing. So how should the process work, and how that's supposed to work? Well, lately presidents have been nominating justices, and then Judiciary Committee goes through the hearings, and this can drag on and drag on and drag on. A case in point, last Justice Kavanaugh. I think the Republicans have learned that this can be very ugly, and the whole process becomes more of a how do we destroy the person rather than just to see if they're qualified. And the qualifications are really not that difficult. Joe the plumber, like I said, can be a justice because you don't have to be a lawyer. You don't even have to be American citizens. We had a guy from Vienna, name was Frankfurter. No pun intended there with the hot dogs. But he was a justice on the Supreme Court. So there's no age. The Supreme Court, the Constitution does not specify the age, the nationality, the gender, the sex orientation, the law degree, no law degree. One justice was actually never completed the high school. He was a clerk to one of the judges, learns a lot about the law and the procedures and whatnot, and took a bar exam. Again, this is back in 1800s, maybe not as rigorous as it is today. So he took the bar exam, passed the bar exam, and he was a lawyer, but he never finished the high school. So there's no constitutional requirements that anybody has to be a certain qualification. So the process can be as simple as on Saturday, President nominates some person, whoever that is. On Tuesday, the Senate is back in session. They vote on it. 50 votes, 51 votes, guarantees it, because those are the rules of the Senate, and that person becomes the justice on the Supreme Court. As simple as that. The whole idea of sending this nomination to Judiciary Committee, going through weeks and months of scrutinizing and basically trying to destroy the person, because remember, Kavanaugh was asked over 1,400 questions. And he almost was proclaimed to be the serial rapist and killer and who knows what else, which none of that came, of course, none of them came out true. So look at the facts. It is very simple. The procedure is actually very simple. Constitution requires the president to nominate someone. Senate confirms it, votes on it, approves it up or down, and as simple as that. And again, as Obama told us, quote, elections have consequences. So Republicans control Senate and the presidency, and that's what the Supreme Court process is. Nancy Pelosi, Speaker of the House, has nothing to do with this. She is totally powerless because the House is not involved. I ask you to subscribe to my channel. You know how YouTube works. Whether you like the video or not, sometimes it's just good to get second opinion. Instead of getting all emotional, look at the facts, and the facts are very simple. So, hope this helps you. Take care.